How Trump's big, beautiful bill is impacting student loan debtors. This video is for our debtor attorneys, our bankruptcy attorneys around the country who don't understand the impact that this big, beautiful bill is having on their practice in the upcoming months. I'm here with Ed Boltz, managing partner of the law office of John Orchid, North Carolina, by far North Carolina's preeminent debtor attorney and former president of NACBA. Ed, good to see you.
See you, Philip. How are you?
Good. With this video, we're going to include an article that you wrote with Igor from Stretto on the impact of the big, beautiful bill. But I just want to unpack this because you put in your article, this isn't a policy change. It's a cliff for debtors, and it's going to roll into how it impacts debtor attorneys nationwide, right?
Yeah.
So let's just start off with that, and then we'll unpack it together.
I think the biggest change is not even necessarily directly part of the one big beautiful bill. It's that student loans are, after basically 5 years during the pandemic and the tail of that, of no collections or very little collections, they're backing collection, and people are going to start seeing their wages garnished if they fall into delinquency and default. Right.
Yeah. Late wages garnished because of their student loans.
Right.
And of the 43 million Americans in student loans, currently 5 to 6 million are
Maybe.
being default. So we're talking a lot of debtors here, right?
Right, and what that can mean is that when up to a quarter of their paycheck above I think it's 150% of the poverty line can be garnished with 30 days notice. It's not a lawsuit. It's a letter that says we're taking a quarter of your paycheck starting in 30 days. And for a lot of people, there are lots and lots of options. The one big beautiful bill, perhaps not one of the bad things about it, is a lot of bad things in it for student loan borrowers, but it does simplify the number of options to a standard repayment and an income-driven repayment plan called the Repayment Assistant Plan, or RAP. But it simplifies this, but there's still lots of options for how to get out of delinquency and default on your student loans. And that includes doing consolidations where you take your loans and roll them all up into one. There's also rehabilitations where you make a minimum payment for a period of 9 months and they get taken out of default. A lot of these are great and they're going to continue. The difficulty is that they take longer than 30 days. So a lot of people are going to see a garnishment coming down the pike, and these options, even if they couldn't find someone who could help them navigate the complexities of this, which is hard, they're not going to have time. And we can talk about both of those paths.
So the magnitude of this is seismic. First of all, have you ever seen wages garnished because of a student loan?
Oh, absolutely.
Oh, you have. Oh, okay. Okay.
This is before the pandemic. It's just, it wasn't, and if you can remember back to 2018 and 19, everybody was fat and happy. So, bankruptcies, we thought were at an all-time low until those fell into the ocean, right? But, we did see wage garnishments back then, and, you would have to navigate those one way or another too to help people.
Okay. Does this matter on private versus public student loans or talking?
No, it does. It does. We're just talking about the government student loans right now. Private student loans, they can only garnish by getting a lawsuit and then a judgment, and the debtor living in a state that has wage garnishment. So here in North Carolina, private student loans, not garnishable. We have no wage garnishment. Up in Virginia, garnish for private student loans.
Okay, my bad on that. I missed that distinction. Okay, so there were garnishments going through 2018, 2019 like normal. Then we go 5 years where no one was paying on student loans per the Biden administration. The Trump administration comes in and says, guess what? Time to pay. You wrote about how it's going to be 9 months from May when these garnishments may start.
So there's always, as lawyers, we have terms of art, right? So when it comes to being late on your student loans, the two important words are that you're delinquent, and that's when you're gone more than 90 days without making a student loan payment, so 3 months. And then you're in default if you've gone more than 270 days without a student loan payment.
Okay.
And so that, so 9 months. So if you're more than 9 months out without student loans, that's when you'll be declared in default, and that's when the bad things start happening to you. The credit reporting, the administrative wage garnishment. We're truthfully likely to start seeing lawsuits by the federal government, particularly against higher income or we used to see these most commonly against doctors and lawyers who had, people who graduated with law and medical degrees,
Right.
that it would, oh, you're a lawyer. Most consumer debtors attorneys will laugh at this. You must be fantastically wealthy, right? So we'd see those, but those are the things that happen once you're in default. So 9 months out.
Okay, so Ed, you're a debtor attorney. Debtor attorneys are listening to this recording. A lot of debtor attorneys like don't even know where to begin on this. They don't want to go down the adversary route. They don't want to go down the student loan route. How do you get paid? What do you do? Et cetera, et cetera. Talk to them directly in their shoes. Someone who hasn't done anything with student loans. Where's the opportunity coming here?
Right. So I think that a good thing about student loans is that as an attorney, you can sort of wade in gradually here, right? So one of the first things you can do is what we used to do with student loans up until 2015 or so, when people started becoming more aware of all these options, is you just put them in a Chapter 13 bankruptcy, and they pay what the means test and their, other obligations under the Chapter 13 plan might be. That may be as little as nothing, right, to their student loans, because student loans are not a priority debt. They're just another unsecured debt like credit cards, medical bills. So you can put somebody in a Chapter 13 plan with nothing else. That's just basic. And they don't have to pay anything for 5 years. Now, interest still accrues. And if you don't do anything more, it won't be discharged, right? But that gives your client 5 years to figure some things out, whether that's to get a better job, how to get enrolled in one of these programs. Maybe things change again because and there's a greater relief. But it gives people time, right? And that's often what bankruptcy is about: is buying time for the borrower. So that's just the simplest, and any consumer bankruptcy attorney should be able to handle that. And then you should be, it's just a simple Chapter 13. A Chapter 7 doesn't do a ton. That buys them 5 or 6 months of breathing room, which but that may be enough to get rid of all their other debts so that they can afford their student loans. So I'll take that back a little bit. Even on Chapter 7, somebody who does primary Chapter 7, if you can free up enough income, otherwise that may be enough. You can then go deeper into that, where you start doing what I call, and I think generally are called, the Buchanan provisions in a Chapter 13 plan. And those are a set of provisions that you put in your Chapter 13 plan that lets the debtor enroll or stay enrolled in an income repayment plan. And the advantage to that is, if they're enrolled in the plan, they will eventually get some forgiveness. And those plans, the new RAP plan under the One Big Beautiful Bill, is going to have minimum of $10 a month student loan payments, but $10 is manageable for, you can find that, right, for most people. And so they might, and then by doing that, they're at least making some progress on their student loans. The time period for forgiveness is stretched out now to as long as 30 years. So that's not great, but at least it's some progress, so your client has some long-term goal. You can then escalate beyond that, even in the appropriate circumstances, to doing a student loan adversary proceeding, where the guidance that was put in place in November of 22 by the Biden administration was actually begun by the first Trump administration. They're the ones who started working with us at NACBA and NCLC and others to say, how could we rearrange this? It's still in place, and people are still getting student loan discharges agreed to by the federal government since this under the President Trump administration. It's not easy, but as a debtor's attorney, you can get paid for this. And I've done these successfully. They're extra, but there's something you can do. And then you can go even deeper into that. You can get into all the borrower defense to repayment lawsuits and actions and all the other jumble of alphabet letters that people have for those sorts of things. But it's, but you don't have to just start off by knowing everything.
Right.
So that's really what my advice is.
So the 13's an easy route for people just to put their clients in a 13. Let's circle on the adversary a little bit, because we've had a lot of our attorneys that have had a lot of success. I mean, significant success with finding someone if they're under the means test, they qualify for a Chapter 7. Correct me if I'm wrong on that. Those are the primo borrowers for the
No,
adversary.
you
Right.
can also do it with a Chapter 13 debtor
Oh,
too.
I didn't realize that. Okay, so you find a debtor that files bankruptcy and you file an adversary. In your paper, you said that 85% of the adversaries filed received the full discharge.
Correct. Yeah. For the first almost 2 years of the program, 85% of people were successful in getting those. Now, that's obviously a self-selecting number because you don't file an adversary somebody making 250 grand and no kids and
Of
just
course. No, no, but it's still the work that's done and submitted. I mean, 85% are done. Strato has a great software associated with this where it actually writes the adversary for you, right?
yeah, you're able to that's I think the advantage of the SLAP guidance is that it lets you as a debtor's attorney pre-screen and give your client reliable advice because it used to be that you say, all right, we can do this, and it's going to be a nightmare. It's going to be full on federal litigation with discovery and depositions and pretrial hearings and summary judgments and blah blah blah. And I'm going to have to charge you an arm and a leg, and I have no guarantee of the result. Now you can go in and say, "Wait, we got a 75 to 85% chance of success here."
That's a huge win. That's a huge odds. Now, Ed,
You can do that by spending a half an hour of time evaluating that case with
now there's also, I never forget, I think you may have said it. I don't remember exactly, but that one NACBA, it was actually no, actually you weren't, you did not say it because it was in Colorado where, yeah, where they were like, you have a fiduciary responsibility as a debt attorney to bring this up. Like you have got to include this in your
I
intake.
think probably always a little overstated
Oh,
because but I think you have to be able to say something to your client about their student loans, right? Whether that's as simple as saying we're not set up, we're not set up to do this. This is extra and we don't do that. But here's somebody who does, right? And just like I will when somebody comes to me and they want a Chapter 11 for their business, I send them to somebody else, right? Because that's not my area of expertise where I can do good for the client and do well by myself and my team, right?
yeah.
If you can't do student loans, you should find somebody who you can partner with who can
Well,
handle those.
and for these adversaries, for the people that fit into that box, right?
Yeah.
I mean, the financing is very good for the debtor attorney. I mean, I believe the Northern District of California actually has a no-look fee for a student loan adversary, right?
Yeah, I do. Yeah, the
It's
problem
like
with that,
$3,500-ish or somewhere around there.
I think they're $4,000, which is about what I charge. Always the difficulty though is getting clients to pay that, right? And finding somebody you're really looking for somebody who's broke enough to pass the adversary proceeding criteria, but still has some money. Enough money that they can come up with a couple $100 a month to pay you in a year or two, right?
And we have attorneys who charge either $200 or $300 a month for 36 months, and they file the adversary after the bankruptcy. Obviously, the bankruptcy needs to be filed first, and they file the adversary a year after that. I have one attorney that started with his past clients, charges $200 a month up front, and will not file anything, don't do any work until it's fully paid up front. So,
right.
but the thing is, this is what I've always been confused about. $3,000, $4,000 for an adversary is like 2 bankruptcies. It's the equivalent of a bankruptcy and another one.
Yeah, it's 2 Chapter 7s.
Yeah, I mean, so it's really something that we could look at and, as a debtor attorney, understand what's going on, run them through Strato software. I mean, you put it all in. You have the client download their NSLDS file, you put in the Strato software after a 15-minute interview, and it's gonna give you, green dots. It's either 3 green dot, 3 thumbs up or not, and it gives you a lot of clarity for that for relatively easy price. So,
Yeah, and you can do that very quickly and cheaply that assessment so that the client knows, all right, I'm gonna, now the difficulty is if that is if it takes 3 years, what's happening to them now if they file a Chapter 7, for example, right? And they got their general discharge, they can come back with this student loan adversary proceeding later, While they're not in bankruptcy, they're facing collection again, right? So that's where sometimes the Chapter 13 may be the better option, again, because for that, you're paying for that time, right? And you're paying for the, protection of being in bankruptcy that whole time.
And
That's all juggling act.
love it. I want another clarity. I've had attorneys say to me, the adversary doesn't work with the Trump administration. As a matter of fact, I've had attorneys say to me that their assistant U.S. attorney has said, don't file the adversaries. But this is not what you're hearing, feeling. I mean, you're in the trenches here.
Still seeing them come through, it does very much depend on that AUSA because the Department of Education, their staff has been dramatically reduced.
Right.
So, the processing times do take longer, but what we've also seen is while they're being considered, the department, there's no collection action while they're being considered, right? So that by itself buys people time. And it does, one of the biggest things that the guidance did that is unchanged is that for the AUSA, a student loan discharge was no longer counted as a bad mark in their win-loss column, right? That it used to be that, oh, these student loans were discharged. I'm a bad U.S. attorney. I'm never going to, get the promotion from the civil side of things to the criminal side of things. And if I don't get that, then I'll never be able to,
Interesting. Yeah.
put somebody away. And so I'll never be elected to the U.S. representatives. And then I'll never become a senator. And I won't get to be president and my mom won't love me.
Right.
Sort of thing.
State case.
They would never agree to them. Now they're allowed to agree to them. It still does leave in many circumstances if, I've heard this from somebody out in Arizona, Ken Neely, in fact, I think is the one who told me this, is that when he files one, there's 5 assistant U.S. attorneys that they're randomly distributing in a month, and one of them just always says no, right? And if you pull that guy, you're dead in the water. Where the other 4 have varying degrees of personal agreement. And I think that's still probably true. They don't have any pressure they don't have the same pressure from above at the Department of Justice to agree to these now. I think it's more of an ambivalence from above.
And how does a debtor attorney find out where their assistant U.S. attorneys stand? Like, is there a way to
Call them up. You can't. You're not allowed to buy them even a cup of coffee, but you can call them up on the phone. They're the same lawyers who you deal with for whenever you have a problem with the IRS.
Okay.
Any problem with any federal debt, you're dealing with your AUSA. So I know the 2 I deal with, I know them, and I can talk to them, and they again have varying degrees of openness and friendliness.
Right.
The first place you start is you call them up and say, "Hey, I don't want to waste your time or my time.
Yes.
So let me tell you about a case and give me your guess on where it's going. What's going to be your take on this?" Right? Or generally, how do you feel about these? You're aiming not to have the judge say that you win and these are undue hardship discharges. You're aiming to get the government to agree to it. And the way my contract is written and the way I think most every attorney who does these is written is there's one fee up to and including an agreement or denial of what we call the attestation for discharge, right? If the government agrees, it's $4,000. Because if the government doesn't agree, the judge is gonna it's a harder standard that you're under with the judge, so you're gonna lose there anyway. So, this fee is up to and including that. If you want to go to trial, great client, $500 an hour, and I want $20,000 to bill against, and you're gonna lose, right? And the reason for that is to make them understand, I'm not just saying you're gonna lose. I'm making you pay to lose, right? So that they don't push you forward on a hopeless quest.
Got it. Ed, what are we missing for the debtor attorney?
I think the thing is that, if you got more energy, you can look around and there are several ports around the country, particularly in Florida, but I also know in Eastern Pennsylvania, I think in Rhode Island, maybe it is, or Connecticut, that have student loan management programs through their bankruptcy courts, which if you're in one of those jurisdictions, you should definitely be taking advantage of those for your clients because Then there's a system, which is what we love, and I think and I know you love, Phil, is having a system that you can, once you know the rules, you can follow those rules, and you can teach your staff and your team how to use those. So if you're in one of those places, take advantage of those. If you're not, find out, talk to somebody at a NACBA conference who is in one of those places about how to get those put into place in your court. Because I think those are a real way to make progress on these.
We're going to do some research on finding these student loan management programs, put it in the notes section of this video. Also, if you're a student loan attorney that wants these type of referrals, please reach out to us. As I mentioned to Ed before the call, I mean, my pathways to referrals are very limited. So if it's something you do or are interested in, please reach out to us. Ed, your final thoughts on this paper, which we will pen as well on this in the notes section. The greatest danger facing student loan borrowers in bankruptcy isn't hostility, it's neglect. Services won't tell them, the trustees won't notice them, the courts won't stop them, only their attorney can. The legal tools are here, the deadlines are set, the clients are walking in your door. Now it's up to us to lead them off away from the edge.
Yeah, that's where I think we are, is people are facing a renewed danger that they haven't had to for half a decade, if or longer. And, whether we're giving them the perfect solution or just a good enough solution, I think that's what we as debtors attorneys have at our fingertips, those options.
Ed, thank you so much. Ed Boltz, former president of the National Association Consumer Bankruptcy Attorney. You're a wealth of knowledge, Ed. Thank you so much.
Thanks, Bill.